Yes, right. This appeal assails the judgment and order delivered by the Division Bench of the High Court of Judicature at Bombay in Criminal Appeal number 46 of 2005, thereby dismissing the appeal of the appellants and maintaining the convictions and sentence of the appellant as passed by the Additional Session Judge Islampur in Session Case number 39 of 2003 for the offence punishable under Section 302 of the Indian Penal Code, signature not verified. Full stop para. The prosecution case, in a brief, as could be gathered from the material placed on record as under para. Deceased Jayashri was married to the accused prior to about 8 or 9 years from the date of the incident. Full stop. They were blessed with two issues. Full stop PW3. Anandi Bai is the mother of the deceased. Full stop PW5. Ramchandra Chintappa is the brother of the appellant, who was residing separately in different parts of the same house. Full stop. It is the case of the prosecution that the appellant was addicted to liquor and used to abuse the beat the deceased, forcing her to get money from her mother. Full stop. On the fateful night of 23rd March 2003, the accused and deceased went to sleep in their house. Full stop. At the dawn of 24th March 2003, PW5 gave a call to a appellant so that they could go to their field for harvesting jawar crop. Full stop. The accused opened the door and expressed his inability to accompany him to the field, stating that Jayashri had committed suicide by hanging. PW4 Ramchandra Shankar resides near the house of the appellant as well as PW5. Full stop. PW5 informed PW4 about the incident. Full stop. PW5 went to the village Punambare to inform the mother of deceased and other relative about the incident. Full stop. PW5 went to Kokrud police station and gave information about the death of the deceased. Full stop. On the basis of information received from PW5, initially advertise number 13/2003 came to be registered. Full stop. Subsequently, crime came to be registered for the offence punishable under Section 302 of IPC. Full stop. As per the advance death certificate, the probable cause of death was asphyxia due to strangulation. Full stop. The charge sheet came to be filed before the jurisdictional magistrate first class para. The case was committed to the learned session judge. Charges was framed for the offence punishable under Section 302 IPC. Full stop. The appellant pleaded not guilty and claimed to be tried. At the conclusion of the trial, the learned trial judge convicted the accused for the offence punishable under Section 302 IPC and sentenced him to imprisonment for life. Full stop. Being aggrieved thereby, the appellant preferred an appeal before the High Court, which came to be dismissed. Full stop. Hence the present appeal. Full stop para. We have heard Shri M. Kumaruddin, learned amicus curiae, appearing on behalf of the appellant, and Shri Sachin Patil, learned counsel, appearing on behalf of the state para. Shri Kumaruddin, learned counsel for the appellant, submitted that the case rests entirely on the circumstantial evidence. He submitted that unless and until the prosecution proves its case beyond all reasonable doubt, conviction in a case of commercial evidence would not be warranted. Full stop. The learned counsel submitted that merely on the basis of suspicion, convictions would not be sustainable. Full stop. He relied in these respects on the judgment of this court in the case of G. Parshawant versus State of Karnataka, bracket 2010 at SCC 593. Full stop para. The learned counsel submitted that in the present case the prosecution has not been in a position to establish that the death of the deceased was homicidal. Pulshap he submitted that if the evidence of PW8 Dr. Kishore Patki is considered, it would reveal that the evidence is inconsistent with the theory of homicidal death. Pulshap in this respects, the learned counsel relied on the judgment of this court in the case of Pulshap para.